Intellectual Property is proudly brought to you by Adams & Adams, rooted in 100 years of excellence in intellectual property law.
Good evening, I'm Stefan Lamprecht and thanks for tuning in to another informative episode of the Intellectual Property Show. We've already covered the need to secure the necessary rights to intellectual property, but how should these rights be protected to maintain a competitive advantage? Chris Job, experienced litigator, is in the studio tonight to tell us more about this crucial aspect of IP management. Good evening, Chris.
Good evening, Stefan.
Chris, I've gone through the whole process of creating new ideas and invention. I've even spoken to somebody to secure the necessary IP rights. Is that enough?
Definitely not, Stefan. In the greater scheme of things, I think it's very important to sit back and just consider why you've done that, and often spending quite a lot of money to achieve those registered rights. Of course, let's not forget that the law does give quite a large extent of intellectual property rights without registration. One thinks of copyright, for example, and also certain common law rights. So it's not always a matter of expenditure. But certainly where one is spending money on registering patents or designs or trademarks, I think it's very important to step back and think about what the purpose is. I really see that in two ways. The first purpose, if you like, is a defensive purpose. It's very useful to hold rights and to be able to indicate, say, a registered trademark or patent, to indicate that on the product or in relation to the service, because that will often act as a deterrent to would-be infringers. Another aspect of that would be in certain respects, and particularly in trademark law, for example, if you have registered the Trademark Act allows you to use that as a shield against any other allegations of infringement by you. In other words, it will protect you against a threat of infringement. But on the more proactive or the positive side of things, the whole point is to register rights and obtain these rights so that you can enforce them. And it's a very sad fact, and maybe it's just a comment on society in general and the whole way that civilizations have developed, because there's always copying that takes place, and one idea leads to another, or a set of first ideas will lead in combination to an innovation, so some form of,
That's the creative process.
So exactly. So the interesting aspect of this is, where does the law draw the line between what can be copied and what can't be copied? But one thing is certain, that copying will occur, and that anybody who innovates, it doesn't matter what field, it can be highly technical, can be highly aesthetic, can be in the marketing context, in any field of endeavor, innovation is always going to be imitated.
So it's for example, the same as I put up a wall around my house, and then I don't go and maintain this wall. I don't go and see if there are branches that are giving access to people and so on. What happens if I've got these rights but I don't enforce them? What's going to happen?
Well, that's where a big danger comes in, and I think in particular in the context of brands and trademarks. If one doesn't enforce rights, a dilution starts to occur. By that I mean that if others start using branding elements, it doesn't have to be a trademark or a word mark, it can be elements of get-up of a product, aspects of a product or of innovation, and it can spread like wildfire, and others can get on the bandwagon, and you then get, it's almost an exponential increment in the extent of the infringement. The first infringer encourages the second encourages the third, fourth, and fifth. So it's a snowballing effect. And many of my clients and my firm's clients take a zero-tolerance attitude. They understand that even small acts of infringement need to be addressed, because they can lead to bigger things and brand dilution and other forms of eventual destruction of the intellectual property right.
So if I think about a company like Microsoft, for example, or a lot of discussion currently with regards to 2010 Soccer World Cup, I've got a brand, and with that brand I've put up a lot of effort to to defend this brand in terms of the promise that I'm making to my customers, and now by pirating or counterfeiting, I'm destructing that brand. I'm taking value away from this customer promise.
There are two types of damage that occur. The destruction of the brand, as you call it, leads to two things. First of all, you will just lose sales. In any field, if you think about selling, whether it's clothing, footwear, any type of product, if imitation takes place, it's obvious you're going to lose sales to the infringers, and that's direct loss in your pocket. But the other and far more insidious form of brand dilution or consequences is brand dilution. It's the destruction of the intellectual property itself. The asset, the commercial asset that intellectual property represents becomes undermined and can become valueless.
Now, I can imagine a large company, I mentioned Microsoft, I think about our own companies in South Africa, Sasol or De Beers, they've got deep pockets to do this kind of litigation and enforcement. But say, for example, I'm in the music industry, I'm an artist. How can I make use of these kind of measures to also see my own value come to right?
A difficult question, obviously, and it's a much larger question than intellectual property and enforcing intellectual property, because access to the courts is a very topical subject in South Africa today, and a very important one, because a lot of people are, just because of the cost of litigation, excluded from the process. But despite that, I think that if you are innovating, if you're a smaller business, for example, there are preemptive things that you can do. I think you should take advice, even if you don't spend money on registering your rights or even litigating, that you should at least know where you stand, and you should learn to recognize these forms of infringement. And I think there are things that you can do yourself. You can write letters, you can try and address the infringement issue, although this is not an easy thing to do, and it's best done with professional advice and assistance. It can be done, and I have clients who tend to represent themselves and at least take the first step. It's an interesting statistic from my firm's practice that, and I have no, of every 100 cases that we commence, files that we open, if you like, probably no more than about 95% actually get resolved, rather. 5% will become actually litigious at the end of the day. So one can head off the infringer at the pass, as it were, by trying to nip it in the bud. There are also, there is a pro bono policy and practice that one can approach the Law Society if one genuinely is indigent or doesn't have the means to litigate. There is an ethical duty on attorneys to assist people who are unable to afford litigation, and certainly my firm and other all attorney firms are on that program, as it were. Okay. So it is possible. One would have to approach the law societies to see whether they would.
Let's go to the other side as a last question. I'm doing business, and suddenly I get a very threatening letter claiming that I am infringing. What should I do? In a South African instance, I'm a small business. How should I respond to that?
I think just look before you leap is my best advice. Think about it and preferably take legal advice. And I must say, of these, I was mentioning statistics of so many cases that one commences. In so many cases, the proceedings should never have been instituted, because it's often a clear case of infringement of the intellectual property right. There is seemingly sometimes a bit of an attitude out there that it's an unfair interference. The Constitution is often brought into a defense strategy or argument. But in point of fact, very often it is ignorance that leads people into deep pocket litigation when it shouldn't.
Thank you very much, Chris, for joining us in the studio tonight. When planning your IP strategy, don't only count the cost and effort in securing the appropriate intellectual property rights, but plan ahead as to your ability to enforce and protect those rights. From me, Stefan Lamprecht, until next week, good night.
Intellectual Property was proudly brought to you by Adams and Adams, rooted in 100 years of excellence in intellectual property law.